Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. Um, in this particular episode, we are continuing with a new installment of series of the EB-5 and issues that either are new or have changed or have been developed through time because of the regulations, the increasing popularity of the EB-5 visa, and other items. So, in this particular episode, I'd like to talk about the I-829 removal process. Now, for anyone who has been married to a foreign national in the U.S., they will notice some similarities. First of all, when you get the green card in the first place through the initial I-526 application, that is akin to when you would be married to the U.S. citizen or lawful permanent resident, and you get not the permanent green card, or you get what's called the conditional green card, and that's for 2 years. And then within 90 days prior to the expiration of that condition, you have to file, and now we're talking EB-5, you have to file the I-829, which is, if it's approved, you then get a removal of the conditional residence and you get the permanent green card. And when I say permanent, it's issued for 10 years at a time, which you need to renew, but it's no longer conditional. And again, if you're comparing this to a marriage case, the I-829 would be similar to an I-751, which is a petition to remove the conditional residence for a married person. So the I-829 has different issues, and before I get into what happens and then some issues regarding the I-829, I want you to be aware that if the I-829 is two things: if it's not filed on time, or if it is denied, it is likely that the investor, and if you are the investor watching this, that you will be put in removal proceedings. Okay, and you'll have to go, or you'll get an order of deportation in absentia. Just so you know, if you do get put in removal proceedings, it is possible to present the application for the I-829 directly to the judge and to allow the judge to make the decision, hopefully to change the decision and approve the I-829, or what happens in more cases than not, since the reality is in immigration court, the trial attorneys don't have a lot of experience with EB-5 petitions, is you can, you being the attorney can negotiate with the trial attorney to get the case terminated and then back in front of USCIS for a redecision on the I-829, or if you just didn't file it in time, for a decision on the I-829. Because just so you know, when you file an I-829, you're not talking about 5 papers or 10 papers. Many times it'll be the size of 3 or 4 books. There are lots and lots of documentary requirements and evidence that properly needs to go in with the I-829. And if you're in removal proceedings, it's not not real easy to move those through, but it certainly can be done. So in that case, if you happen to be an EB-5 investor and you are heading towards removal proceedings because the I-829 was denied or not properly filed, make sure you get an attorney that both knows the EB-5 process and the business side of immigration, as well as the deportation side of immigration. Okay, you'll need an attorney that does both. If you happen to be in that situation, give me a call or send me off an email for consultation. I'll be happy to let you know what can be done. Now, what are the major things, and there's all different kinds of things you have to show, but what are the major things you have to show in an I-829 petition to remove the conditional residence of an EB-5? Well, one is that you have maintained the investment, okay? And that that's actually in some cases harder to do than it sounds. But just as a basic rundown, if you're putting $500,000 in a regional center, let's say, and you get the green card, and let's say that everything's going fine, and I'll just exaggerate here. Let's say that before you actually file the I-829, that you pull out your investment, okay? And basically what happens is if you pull out your investment before the I-829. And by pull out, I mean, let's say the regional center did great, they finished the project, they built the building, and they send you back your $500,000. And let's even say that they send you back a little interest, $500,050. And then you file the I-829. 100% sure it'll be denied. It'll be denied because you did not maintain the investment. Now the question is, how long do you have to maintain the investment? You have to maintain the investment through the entire adjudicative process. That doesn't mean that even after you file the I-829 you can get your money back. Only after approval of the I-829 can you withdraw or get your money back. If it's any time before that, then you will not get an approved I-829. And even if you have the investment in there, and you file the I-829, and before the I-829 is approved, you pull your investment out and you still get an approval. If they find out, they being immigration, that you pulled your investment out too early, they will revoke that approval. Now, most of the time, if you're from any other country than China, it's the process, takes some time. But with China, since they're going to be backlogged and it's going to take longer and longer, and until you can get the I-829 adjudicated, you're looking possibly 5 to 7 years of keeping your money in that investment. With a normal, or basically any other country, you file the I-829. The I-829 takes, more or less about a year. So, first you put the money in there before you file the I-526. Then you get, that takes about, give or take, 6 months to a year. It's actually going down because the immigration has moved the EB-5 processing from the California Service Center to a specially designed center in Washington, D.C. that deals just with EB-5s, which, by the way, is a good thing because not only do they process the I-526s and 829s faster, but they also will allow you to, they have a lot of experts that they've retained. They have economists, they have business people, all kinds of people that help adjudicate now these types of petitions. So, again, if you're from another country other than China, you put the money in for the I-526. It takes about, just say, a year to process, and then you have a conditional green card for 2 years, so that's basically 3 years, and then it's going to take another year to file and get the answer for the I-829, so that's 4 years. So, at a minimum, realistically, you're looking to keep the money in the investment for 4 years. Okay, and of course it could be longer than that. It's possible that it could be shorter, but if you have in your mind that the benchmark for a typical investor not from China will keep the money in there for about 4 years, then you'll be good. So how do you prove that you have maintained the investment? Well, of course, there's the K-1 partnership tax returns. Especially if you're going to be investing in a regional center, then it'll be a limited liability partnership, and you'll get K-1s every year. You'll be able to show that it has been maintained. So that is the first part, the first major part of the I-829. What is the second part that you need to prove in order to maintain, in order to get an approval? Well, you have to prove job creation. Okay, now job creation can be proven in a couple different ways, but it depends if you have a direct investment which is where you have your own company, versus where you have invested the money in a regional center. Okay, let's talk about the direct investment first. The direct investment is somewhat easy to prepare, a little bit easier in actuality, because all you have to do, and by all I mean, of course you have to show this, but you have the employment records, and you have the W-2s, you have all that which you can submit to show 10 full qualified employees. Now, the issue then becomes with the job creation, when does that have to be? Well, the idea is that it normally should be about 6 months after you get an approved I-526, up to 2 years after that time. But it does say, the regs say, within a reasonable time thereafter. So it is possible that you will still be anticipating hiring more people even as you file the I-829 petition. Let me give an example. Let's say that you have, you're building a restaurant, and there were, or a building, whatever it is, and there were delays, and let's say there was an earthquake or whatever it was, and things got delayed, and it finally finished 3 months before the I-829 had to be filed. Well, within that 3 months, you can't just hire everybody right there. So you can explain as to why they haven't yet been hired, but they will be hired as the time goes on. You can give analysis and time frames and so forth. And what you want to do, there are some issues with this. Let's say that you're building a real nice building, okay, and let's say that sure enough you show that it has, when you file the I-829, all the tenants are now in the building and they have employees, and you have no problem getting showing 10 full-time employees. But next door there's another building, an older building, and let's say that a lot of those tenants just moved over to the new building. So it wasn't really a creation of 10 new jobs. In fact, it was just a net of maybe 3 or 4, because it took away from the building right next to it. So there are certain analysis that has to be done in order to show that it is 10 new jobs that have been created, because when it comes right down to it, the EB-5 was really created to make jobs in the U.S. That's the purpose. And if it's not making jobs, but it's transferring from one place to another, then that purpose hasn't been satisfied. So with that type, you do need to get it in. Now, if you buy a business that already has 10 employees or more, and then you try to file the I-829 to show you have 10 employees, that also will not work, because the employees already existed when you purchased the company. You have to make 10 new positions, and they have to be full-time positions, which means 35 hours a week. And you can, there's actually times where you can have 2 part-time employees and consider them as one to satisfy the requirements, but there's some issues on that, and you have to be careful. Now there is talk about having to provide the I-9s for all the employees, but then there is also some resistance in submitting that with the I-829 procedure, because when somebody comes and works for you or for a company, they just look on, the I-9 list, A, B, or C, they provide the documents, and that's it. As an employer, you are prohibited from then going and say, well, I really don't believe that you're legal to work here, even with these documents you showed me. Can you verify that by showing me this and that? You can't do that, because that would be discrimination. It would be in violation of certain other employment practices. But what happens is, if you submit all the I-9s and some of the I-9s turn out not to be valid because the employee was lying about their status, and let's say you submitted 10 of them, and let's say 3 of them are without status, really without status, but lied about it, that means you only have 7 qualified employees, and that means the I-829 is going to be denied. So There are some issues with submitting the I-9s, but if hopefully you can hire people who in fact are legal, or you can submit sufficient documentation in the first place to show that there are uh, 10 qualified employees, then that all works good. Now, let's say you're from California, there's the E6 quarterly wage report and all that, and you can certainly just keep uploading that. If your attorney is on the ball, he or she will have you upload all these employment records every quarter as you get them. So when the I-829 process comes, it will make it much easier to be able to go forward. Now, there's also another issue with the I-829 in that there cannot be a material change in the process. Okay, what does that mean? Well, I'll exaggerate to make the point. Let's say that the I-526 was initially approved to build a huge beauty salon, okay, with 22 different stations, and in downtown Manhattan, and it was going to be the biggest hair salon around, and going to make lots of money with that. And let's say that as a few months after, things just didn't happen, you looked at the economy a little more and decided that it just wasn't proper, and something else fell into your lap. And instead of doing that, you decided to build a really fancy Thai restaurant. Okay, obviously, without doubt, that is a material change. Okay, and if there is a material change from the I-526 to the I-829, it will be denied. Um, so then the question becomes, again, what is a material change? Let's say the 526 said there's going to be a 10-story building, but in fact, because certain things happened, only 8 stories were needed, or maybe 14 stories were built more than what was said. Or let's say that you said that it was going to be built within this particular circle, okay, except it moved a little bit outside the circle. So there's all different kinds of issues that have to be analyzed in which to determine whether or not there was in fact a material change. Obviously, the attorney would want to argue there is not a material change, or if there is a material change, then at the I-526 procedure, or thereafter, you can file an amendment, which of course, unfortunately, that's taken about a year, give or take, to get that approved, assuming it is. Or you can simply file another I-526 if it comes down to it. If there is without question, a material change, get another I-526 filed, and then when this is a little complicated here, but when the I-829 on the first I-526 becomes due, ask for a stay of the decision because of the material change and the new I-526 that was filed, so that once the date comes to file the new I-829, you can go forward with that. Okay, so a lot of information here, but that's essentially the basis of the I-829. And just so you know, again, we're talking, a typical I-829 is going to take about 2-3 books or more of space. Sometimes a whole box is needed in which to send in the proper I-829. I don't want anyone to think the I-829 is a piece of cake, no problem, just because you got the 526 approved. It's going to, if your attorney's doing the right thing, there will be monitoring the entire 2 years. There will be uploading of documents the entire 2 years. And if all that is followed, then it does make the I-829 it does make it considerably easier to get approved. Okay, more on the coming videos.